While we wait for the delivery of Tinubu's academic records to Atiku Abubakar by Chicago State University, let's see the admissibility of the new evidence at the Supreme Court, because a lot of narratives are flying around. They started again. The way they started during the election, even before it, all the narratives eventually played out. The same way they shouted, go to court if you don't agree with the result of the election. And all the narratives that came after the petitioners went to court, most of these narratives eventually played out in courtroom. We saw all of them. And at the end of the day, the judges adopted most of these narratives. They even went as far as manufacturing their own. Even things the respondents didn't argue about, the judges did it on their behalf. Now, new narratives are playing out. No one will be surprised if the Supreme Court adopts this narrative. One lawyer, SAN for that matter, said that Atiku is just wasting his time, that we have passed that stage, that the Supreme Court will never accept new evidence from him. They are now preempting the justices. This is what they tried to do at the United States District Court in Chicago. They wanted to bamboozle the judges to make them understand that the Supreme Court will never accept new evidence, which of course the judge rejected. Anyway, before we see the Supreme Court rules that guides the presentation of new evidence, let's address some questions that many people have raised. Many people are saying, we won't celebrate until these documents are handed over to Atiku, that Tinubu will appeal to another court, blah, blah, blah. First, there will be no appeal. The reason is very simple. Before he can appeal the judgment at the 7th District Court, he must first of all apply for a stay of execution of the current judgment. If he doesn't do that, the judgment will take effect before he will even finalize the appeal at the upper court. And if you observe the judgment of Nancy Maldonado, she made it clear that she will not entertain any further review or appeal or stay of execution. So it means that there will be no time, even if he goes to the next appeal court, before he finishes that process to try and get a stay of execution at the 7th District Court. Time must have passed. So there will be no appeal. Atiku will get all these documents from Chicago State University. These documents are known already. Of course, you are aware, these were released by the same university last year to Enahoreba. All these documents are public documents. The main thing that everyone is waiting for is the deposition. They will ask them questions. This one is the main bombshell. Atiku's lawyers will ask them questions. It might be up to several hours of questioning. The court only controls the topics of the question. It is Atiku's lawyers that determine the type of question to ask. They will only ask those questions that are under the topic already set by the judge. So that one is the main one. They are not expected to lie. They must tell the truth because they know the implication and the repercussion of lying under oath. Remember, this is the United States we're talking about here, not Nigeria or African countries where they do anyhow they want. Here, they don't joke with their law and order. The reason their democracy has survived all these years is because of their rule of law and the independence of the judiciary arm of government. So this one should also answer the question many have been asking, whether they will deliver the real documents. What if they forge documents to match the ones already submitted by Tinubu? Nothing like that is expected to happen. They won't do that. This is the main reason Atiku's lawyers want them to make an oral deposition, so as to give oral backing under oath to what they submitted. They will ask them many questions. This document, where did you get it from? From which record did you get this? All those type of questions. So they will make sure that they are telling the truth. But if in any way they find out that someone is lying, that something doesn't add up, don't be surprised to hear that this has become a criminal investigation. Yes, it's that serious. Now that one SAN has given us a hint of what to expect at the Supreme Court, there is precedence to that. Remember what happened at the Presidential Election Petition Tribunal? Almost all their arguments, even prior to the petitioners filing the petition, we saw them play out in court, and eventually it was all adopted. Now, at the Supreme Court, they are preempting us, preempting the judges. It won't stop us still believing that something good can still come out of it, that they will shame everyone saying that they are corrupt, that they don't uphold the law, that they will use this as an opportunity to redeem themselves. Let's look at the order of the Supreme Court that permits the presentation of new evidence. Yes, the Supreme Court rules are written in black and white, just like the Nigerian Constitution and electoral law, other bylaws. So if anyone follows them judiciously, the result should be predictable. There shouldn't be mago-mago or abracadabra. If you saw the judgment of Nancy Maldonado, you will see the simple English that she used in delivering the judgment. Even if you are not a lawyer, if you read the judgment, you will understand it. That is how the court should operate. That is how to communicate with the public. You are a government, after all. They are an arm of government. So following the rules should be predictable. But in this situation, Nigeria might happen. And you will say, hey, how did this happen? I followed everything to the letter. Why should the result not be predictable? Like in other same countries, when you read the law, you are expecting when you come to court that it will be applied. But they end up doing you is black, is white. Which one is it? Something that you're saying that it is black, they will tell you, no, it is white. That's the end. Looking at the Supreme Court rules, the one that concerns us is Order 2, Rule 12, which is the procedure for receiving further evidence on appeal. Number 1, a party who wishes the court to receive the evidence of witnesses, whether they were or were not called at the trial, or to order the production of any document, exhibit, or other thing connected with the proceedings in accordance with the provisions of Section 33 of the Act, shall apply for leave on notice of motion prior to the date set down for the hearing of the appeal. Number 2, the application shall be supported by affidavit of the facts on which the party relies for making it and of the nature of the evidence or the document concerned. Number 3, it shall not be necessary for the other party to answer the additional evidence intended to be called, but if leave is granted, the other party shall be entitled to a reasonable opportunity to give his own evidence in reply if he so wishes. This number 1 is very, very important to Atiku's case because going by what it says, that even if the witness was called at trial or not, that the evidence can still be tendered, which means it is admissible at the Supreme Court. Yes, it can't get better than this, but always remember that it is still at the discretion of the honorable justices. They might decide for no reason to say we are not receiving the new evidence. They might also say, okay, let's receive it, let's see it for fair hearing. But considering how this election petition is very important in Nigeria right now, if they uphold this section pro bono the way it is written, that means it will trump whatever technicality the appeal court justices relied on, saying that it was not front-loaded. Yes, that's what they said, while throwing the evidence away. So if the Supreme Court rule says that whether the evidence was called at trial or not, that they can admit that evidence, that means Atiku can tender these documents when he receives them. The same way people don't understand the concept of leadership, what is expected of a leader, his attributes and character, is the same way they don't understand the concept of justice. These are people who wouldn't bat an eyelid and suggest jungle justice on someone who stole a loaf of bread. If there is a scale for crime that you can weigh them and say this one is heavier or this one is worse, that of the person who stole a loaf of bread pales in comparison to what politicians steal, to what people in high places, to what civil servants who use ordinary pen to write away billions of naira belonging to the state. The worst part is that most of these petty crimes are caused by lack of good governance. When politicians steal all the money that is supposed to be used to develop the country, provide jobs for people, this is what you see in the society. Not that any crime is pardonable, but when one descends to the level of stealing a loaf of bread, you know that there is a problem. So to all the people who suddenly develop cold feet because the crime of a politician they love is being discussed, will you develop hot feet when the crime of a politician you don't love is being discussed tomorrow? Thanks for watching.